The Constitution of the United Kingdom of Great Britain and Northern Ireland is the sum of laws and principles that make up the body politic of the United Kingdom. It concerns both the relationship between the individual and the state, and the functioning of the legislature, the executive and judiciary. Unlike many other nations, the UK has no single constitutional document. This is sometimes expressed by stating that it has an uncodified or unwritten constitution. Much of the British Constitution is embodied in written documents within statutes, court judgments, works of authority and treaties. The Constitution has other unwritten sources, including parliamentary constitutional conventions. The bedrock of the legislative British Constitution since the Glorious Revolution of 1688 has been described as the doctrine of parliamentary sovereignty, that is, the statutes passed by Parliament are the UK's supreme and final source of law. It follows that Parliament can change the Constitution simply by passing new Acts of Parliament. There is some debate about whether the principle of parliamentary sovereignty remains valid, particularly in the light of the UK's membership of the European Union. Another core principle of the British Constitution, as enunciated by the legal scholar Albert Vendici, is the rule of law. History. In 2004, a joint committee of the House of Commons and the House of Lords discussed that the fundamental parts of constitutional law could be taken to include the following statutes: Magna Carta 1215, clauses 1, 9, and 29, as enumerated in 1297, remain in statute, asserts the freedom of the English Church, the liberties of the City of London among others, and establishes the right to due process. Bill of Rights 1689 asserts certain rights of Parliament and limits the powers of the monarch. Crown and Parliament Recognition Act 1689 confirms the succession to the throne and the validity of the laws passed by the Convention Parliament. Act of Settlement 1701 settles the succession of the Crown. Acts of Union 1707, Union of England and Scotland. Act of Union 1800, Union of Great Britain and Ireland. Parliament Acts Chapter 1911 and 1949 asserts the supremacy of the House of Commons by limiting the legislation blocking powers of the House of Lords. Life Peerages Act 1958 establishes standards for the creation of life peers which give the Prime Minister the power to change the composition of the House of Lords. Emergency Powers Act 1964 provides power to employ members of the armed forces in work of national importance. European Communities Act 1972 incorporates European law into UK law. House of Commons Disqualification Act 1975 prohibits certain categories of people, such as judges, from becoming members of the House of Commons. Ministerial and Other Salaries Act 1975 governs ministerial salaries. British Nationality Act 1981 revises the basis of British nationality law. Senior Courts Act 1981 defines the structure of the Senior Courts of England and Wales. Representation of the People Act 1983 updates the British electoral process. Scotland Act 1998 creates the Scottish Parliament and devolves certain powers to it. Government of Wales Act 1998 creates the Welsh Assembly and devolves certain powers to it. Northern Ireland Act 1998 creates the Northern Ireland Assembly and devolves certain powers to it. Human Rights Act 1998 incorporates the European Convention on Human Rights into UK law. House of Lords Act 1999 reforms the House of Lords, removing most hereditary Affairs. Civil Contingencies Act 2004 establishes a framework for national and local emergency planning and response. Since then, the following statutes of a constitutional nature have become law. Constitutional Reform Act 2005 creates the Supreme Court of the United Kingdom and guarantees judicial independence. Constitutional Reform and Governance Act 2010 reforms the royal prerogative and makes other significant changes. Fixed-Term Parliaments Act 2011 introduces fixed-term parliaments of 5 years. Succession to the Crown Act 2013 alters the laws of succession to the British throne. General constitutional principles. Sources: Acts of Parliament are bills which have received the approval of Parliament, that is, the monarch, the House of Lords and the House of Commons. On rare occasions, the House of Commons uses the Parliament Acts to pass legislation without the approval of the House of Lords. It is unheard of in modern times for the monarch to refuse to assent to a bill, though the possibility was contemplated by George V in relation to the fiercely controversial Government of Ireland Act 1914. Acts of Parliament are among the most important sources of the Constitution. According to the traditional view, Parliament has the power to legislate however it wishes on any subject it wishes. For example, most of the iconic medieval statute known as Magna Carta has been repealed since 1828, despite previously being regarded as sacrosanct. It has traditionally been the case that the courts are barred from questioning any Act of Parliament, a principle that can be traced back to the medieval period. On the other hand, this principle has not been without its dissidents and critics over the centuries, and attitudes among the judiciary in this area may be changing. One consequence of the principle of parliamentary sovereignty is that there is no hierarchy among Acts of Parliament. All parliamentary legislation is, in principle, of equal validity and effectiveness. However, the judgment of Lord Justice Laws in the Thoburn case in 2002 indicated that there may be a special class of constitutional statutes, such as Magna Carta, the Human Rights Act 1998, the European Communities Act 1972, the Act of Union and Bill of Rights, which have a higher status than other legislation. This part of his judgment was obiter and, indeed, was controversial. It remains to be seen whether the doctrine will be accepted by other judges. Treaties do not, on ratification, automatically become incorporated into UK law. Important treaties have been incorporated into domestic law by means of Acts of Parliament. The European Convention on Human Rights, for example, was given further effect into domestic law through the preamble of the Human Rights Act 1998. Also, the Treaty of Union of 1707 was important in creating the unitary state which exists today. The treaty was between the governments of England and Scotland and was put into effect by 2 Acts of Union which were passed by the parliaments of both nations. The treaty, along with the subsequent acts, brought into existence the Kingdom of Great Britain, uniting the Kingdom of England and the Kingdom of Scotland. Common law legal systems exist in Northern Ireland and in England and Wales, but not in Scotland, which has a hybrid system which includes a great deal of common law. Court judgments also commonly form a source of the Constitution. Generally speaking, in English law, judgments of the higher courts form precedents, a case law that binds lower courts and judges. However, Scots law does not accord the same status to precedent, and judgments in one legal system do not have a direct effect in the other legal systems. Historically important court judgments include those in the case of proclamations, the ship money case and Entick v. Carrington, all of which imposed limits on the power of the executive. A constitutional precedent applicable to British colonies is Campbell v. Hall, which effectively extended those same constitutional limitations to any territory which has been granted a representative assembly. Many British constitutional conventions are ancient in origin, though others date from within living memory. Such conventions, which include the duty of the monarch to act on the advice of his or her ministers, are not formally enforceable in a court of law. Rather, they are primarily observed because of the political difficulties which arise if they are not. Works of authority is the formal name for works that are sometimes cited as interpretations of aspects of the UK Constitution. Most are works written by 19th or early 20th century constitutionalists, in particular A.V. Dicey, Walter Bagehot and Erskine May. Parliamentary supremacy in the 19th century. A.V. Dicey, a highly influential constitutional scholar and lawyer, wrote of the twin pillars of the British Constitution in his classic work Introduction to the Study of the Law of the Constitution. These pillars are the principle of parliamentary sovereignty and the rule of law. Parliamentary sovereignty means that Parliament is the supreme law-making body. Its acts are the highest source of English law. According to the doctrine of parliamentary sovereignty, Parliament may pass any legislation that it wishes. Historically, no act of Parliament can be unconstitutional, for the law of the land knows not the word or the idea. By contrast, in countries with a codified constitution, the legislature is normally forbidden from passing laws that contradict that constitution. Constitutional amendments require a special procedure that is more arduous than that for regular laws. There are many acts of Parliament which themselves have constitutional significance. For example, Parliament has the power to determine the length of its term. By the Parliament Acts Chapter 1911 and 1949, the maximum length of a term of Parliament is 5 years, but this may be extended with the consent of both houses. This power was most recently used during World War II to extend the lifetime of the 1935 Parliament in annual increments up to 1945. Parliament also has the power to change the makeup of its constituent houses and the relation between them. Examples include the House of Lords Act 1999, which changed the membership of the House of Lords. The Parliament Acts Chapter 1911 and 1949, which altered the relationship between the House of Commons and the House of Lords. And the Reform Act 1832, which made changes to the system used to elect members of the House of Commons. The power extended to Parliament includes the power to determine the line of succession to the British throne. This power was used to pass His Majesty's Declaration of Abdication Act 1936, which gave constitutional effect to the abdication of Edward VIII and removed any of his putative descendants from the succession, and most recently to pass the Succession to the Crown Act 2013, which changed the succession to the throne to absolute primogeniture and also removed the disqualification of marrying a Roman Catholic. Parliament also has the power to remove or regulate the executive powers of the monarch. Parliament consists of the monarch, the House of Commons and the House of Lords. In recent times the House of Commons has consisted of more than 600 members elected by the people from single-member constituencies under a first-past-the-post system. Following the passage of the House of Lords Act 1999, the House of Lords consists of 26 bishops of the Church of England, 92 representatives of the hereditary peers and several hundred life peers. The power to nominate bishops of the Church of England and to create hereditary and life peers is exercised by the monarch. on the advice of the Prime Minister, by the Parliament Acts Chapter 1911 and 1949. Legislation may, in certain circumstances, be passed without the approval of the House of Lords. Although all legislation must receive the approval of the monarch, no monarch has withheld such assent since 1708. The House of Commons alone possesses the power to pass a motion of no confidence in the government, which requires the government either to resign or to seek fresh elections. Such a motion does not require passage by the Lords or royal assent. Parliament traditionally also has the power to remove individual members of the government by impeachment, although this power has not been used since 1806. By the Constitutional Reform Act 2005, it has the power to remove individual judges from office for misconduct. Additionally, Dicey has observed that the Constitution of Belgium comes very near to a written reproduction of the English Constitution. Rule of law. The rule of law was A.V. Dicey's second core principle of the UK Constitution. This is the idea that all laws and government actions conform to principles. These principles include equal application of the law. Everyone is equal before the law and no person is above the law, including those in power. Another is that no person is punishable in body or goods without a breach of the law. As held in Entic v. Carrington, persons are free to do anything, unless the law says otherwise, thus, no punishment without a clear breach of the law. Unity and devolution. The United Kingdom comprises 4 countries: England, Wales, Scotland and Northern Ireland. Nevertheless, it is a unitary state, not a federation, nor a confederation. Although Scotland, Wales and Northern Ireland have possessed legislatures and executives, England does not. The authority of all these bodies is dependent on Acts of Parliament, and they can in principle be abolished at the will of the Parliament of the United Kingdom. A historical example of a legislature that was created by Act of Parliament and later abolished is the Parliament of Northern Ireland, which was set up by the Government of Ireland Act 1920 and abolished, in response to political violence in Northern Ireland, by the Northern Ireland Constitution Act 1973. The Greater London Council was abolished in 1986 by the Local Government Act 1985, and a similar institution, the London Authority, was established in 2000 by the Greater London Authority Act 1999. Parliament contains no chamber comparable to the United States Senate or the German Bundesrat. England contains over 80% of the UK's population and produces over 80% of its combined gross domestic product. In England, the established church is the Church of England. In Scotland, Wales and Northern Ireland, there is no state church. The respective state churches were disestablished by the Church of Scotland Act 1921, the Welsh Church Act 1914, and the Irish Church Act 1869. England and Wales share the same legal system, while Scotland and Northern Ireland each have their own distinct systems. These distinctions were created as a result of the United Kingdom being created by the union of separate countries according to the terms of the 1706 Treaty of Union, ratified by the 1707 Acts of Union. Reforms since 1997 have decentralised the UK by setting up a devolved Scottish Parliament and assemblies in Wales and Northern Ireland. The UK was formed as a unitary state, though Scotland and England retained separate legal systems. Some commentators have stated the UK is now a quasi-federal state. state. It is only quasi-federal, because England has no legislature of its own, and is directly ruled from Westminster. Attempts to extend devolution to the various regions of England have stalled, and the fact that Parliament functions both as a British and as an English legislature has created some dissatisfaction. European Union membership under European law, as developed by the ECJ. The EC Treaty created a new legal order under which the validity of European Union law cannot be impeded by national law, though the UK, like a number of other EU members, does not share the ECJ's monist interpretation unconditionally. It accepts the supremacy of EU law in practice, because, in the UK, international law is treated as a separate body of law. EU law is enforceable only on the basis of an Act of Parliament, such as the European Communities Act 1972, which provides for the supremacy of EU law. The supremacy of EU law was confirmed by the House of Lords in the factotum litigation, in which part of the Merchant Shipping Act 1988 was disapplied because it conflicted with EU law. In his judgment in factotum, Lord Bridge wrote, "The supremacy within the European Community of community law over the national law of member states was certainly well established in the jurisprudence of the European Court of Justice long before the United Kingdom joined the community. Thus, whatever limitation of its sovereignty Parliament accepted when it enacted the European Communities Act 1972 was entirely voluntary. Under the terms of the Act of 1972, it has always been clear that it was the duty of a United Kingdom court, when delivering final judgment, to override any rule of national law found to be in conflict with any directly enforceable rule of community law. Thus there is nothing in any way novel in according supremacy to rules of community law in those areas to which they apply, and to insist that, in the protection of rights under community law, national courts must not be inhibited by rules of national law from granting interim relief in appropriate cases is no more than illogical. Recognition of that supremacy. In 2015, the Court of Appeal disapplied parts of the State Immunity Act 1978 on the grounds that it conflicted with Article 47 of the Charter of Fundamental Rights of the European Union. The case concerned two workers who wished to sue the Sudanese embassy in London for violations of employment law. On one analysis, EU law is simply a subcategory of international law that depends for its effect on a series of international treaties. It therefore has effect in the UK only to the extent that Parliament permits it to have effect, by means of statutes such as the European Communities Act 1972, and Parliament could, as a matter of British law, unilaterally bar the application of EU law in the UK simply by legislating to that effect. However, at least in the view of some British authorities, the doctrine of implied repeal, which applies to normal statutes, does not apply to constitutional statutes, meaning that any statute that was to have precedence over EU law would have to provide for this expressly or in such a way as to make the inference irresistible. The actual legal effect of a statute enacted with the express intention of taking precedence over EU law is as yet unclear. However, it has been stated that if Parliament were to expressly repudiate its treaty obligations, the courts would be obliged to give effect to a corresponding statute. If the time should come when our Parliament deliberately passes an act with the intention of repudiating the treaty or any provision of it, or intentionally of acting inconsistently with it, and says so in express terms, then It would be the duty of our court to follow the statute of our Parliament. In 2011, Parliament passed the European Union Act 2011, which states in Clause 18, "Directly applicable or directly effective EU law of the European Communities Act 1972 falls to be recognized and available in law in the United Kingdom only by virtue of that act, or where it is required to be recognized and available in law by virtue of any other act." Following the accession of the UK to European Economic Community in 1972, the UK became bound by European law and, more importantly, the principle of the supremacy of European Union law. According to this principle, which was outlined by the European Court of Justice in 1964 in the case of Costa v. Penal, laws of member states that conflict with EU laws must be disapplied by member states' courts. The conflict between the principles of the primacy of EU law and of parliamentary supremacy was illustrated in the judgment in Thoburn v. Sunderland City Council, which held that the European Communities Act 1972, the act that initiated British involvement in the EU, could not be implicitly repealed simply by the passing of subsequent legislation inconsistent with European law. The court went further and suggested that the 1972 Act formed part of a category of special constitutional statutes that were not subject to implied repeal. This exception to the doctrine of implied repeal was something of a novelty, though the court stated that it remained open for Parliament to expressly repeal the Act. Following the UK-EU referendum in June 2016, it is politically conceivable that Parliament would now do so, but constitutional lawyers have also questioned whether such a step would be as straightforward in its legal effects as it might seem. The Thoburn judgment was handed down only by the Divisional Court, which occupies a relatively low position in the legal system. Important conventions relating to monarchy. The monarch shall grant the royal assent to all bills passed by Parliament. The monarch will ask the leader of the majority party in the House of Commons to form a government, and if there is no majority party, the person who appears most likely to command the confidence of the House of Commons to serve as Prime Minister and form a government. The monarch will ask a member of the House of Commons to form a government. It remains possible, however, for a caretaker Prime Minister to be drawn from the House of Lords. All ministers are to be drawn from the House of Commons of the House of Lords. The House of Lords will accept any legislation that was in the government's manifesto. In recent years, this convention has been broken by the Lords, though the composition of the Lords has radically changed since the convention was introduced. Individual ministerial responsibility, cabinet collective responsibility,